Okay, this is a new topic, and also this is my first time teaching this topic because this is the first time that they are including this uh, matter in the CPA board licensure examination as reflected in the CPA board licensure examination terms of specifications and syllabus, which will be effective in the year 2022. Okay, so this is part 1. So this is about Republic Act number 10142, okay, which was approved on February 2, 2010, or about 11 years ago. Okay. The title of this law is Financial Rehabilitation and Insolvency Act of 2010. Okay. So that is why it is also called FRIA because of its acronym. Okay. And the full title is actually reads an act providing for the rehabilitation or liquidation of financially distressed enterprises and individuals. Okay, I am underscoring enterprises and individuals to emphasize that this law applies to businesses. That is why it's called enterprises, no businesses yan. And also to individuals who may or may not be engaged in businesses but are already financially distressed. So applicable sa both enterprises, whether uh, natural person or juridical person who are into businesses, so they are called enterprises, and also individuals. I know that you have not yet discussed or encountered your uh, law on partnership and corporation. So unfortunately, this topic involves corporation and partnership. So for purposes of this discussion, I will make it easier for you to understand. By the way, class, ang corporation are actually considered as persons just like you and me. Okay, a corporation is an artificial person because the law says so. Okay, kung ang individuals pinapanganak with a birth certificate, corporations pinapanganak din when it is approved by the Securities and Exchange Commission. At yan, ang pinaka-birth certificate niya is yung Articles of Incorporation or yung Certificate of Registration. I mean, okay? So just remember that when I say juridical person, I am referring to those corporations registered with the Securities and Exchange Commission. And when I say natural persons or natural individuals, I am referring to not natural persons just like you and me, or individuals just like you and me. So FRIA. So we shall for brevity, we will call this law FRIA. Okay. We will not call this FRIA law because that will be redundant. Because A in FRIA means act. Tapos nagdagan mo pa ng law, parang act law. FRIA act law. Financial rehabilitation, insolvency, and act law. Pang awkward. So just FRIA. Okay, the objective of FRIA is actually to encourage debtors, naka-underline, both juridical and natural persons, and their creditors to collectively and realistically resolve and adjust competing claims and property rights. Okay, so this law actually class is about kanang uh, persons, whether juridical or natural persons, who are financially have I mean they have financial difficulties in meeting their obligations. Okay, so in that scenario, you will have the debtor, yung nangutang, meron siyang properties and property rights. And his property may be encumbered or unencumbered. When you say encumbered, it may be na pledge, na mortgage. Okay. So in that case, the property is called that property is encumbered property. Okay. In layman's term, it is called naging collateral na prenda. And some of these properties are unencumbered, meaning those are properties which are free and have not been pledge, mortgage to any creditor. So ito si debtor. Pero meron siyang problem, financially distressed siya. On the other side, meron tayong creditors. The creditors have claims, of course. And some creditors have secured claims, and some are unsecured claims. When you say secured claims, okay, these creditors, okay, when they extended credit to the debtor, magkakaroon ng pledge or mortgage or some other lien over the property. Okay, if you can still remember your lien over the property under your loan sales, kasama din yun sa secured claims. Okay? And some creditor extended credit to the debtor without any security or collateral or mortgage or pledge. So, ang tawag doon, unsecured claims. So, in the event that the debtor will be financially distressed, in common terms, in layman's term, ang tawag nila bankrupt. Pero bankrupt is a very loose term. For purposes of technicalities, okay, under FRIA, it is called insolvency. Okay, insolvency. So, in case of insolvency of the debtor, usually the creditor would run after the debtor and grab his properties. Okay, hihilain ni creditor ang mga properties niya. So, this is the scenario being covered by FRIA. So, the FRIA encourages creditor and the debtor to come together and resolve their claims and which conflicts with properties and property rights of the debtor. Okay, they have to come together under FRIA and settle their claims in a civil manner. Hindi yung bara-bara, hila dito, hila doon. Okay, so ito yung objective ng FRIA. The nature of proceedings under FRIA is called an in rem proceedings. When you say in rem, rem means the property. Okay, ang pinaka-focus ng court in the event of a court proceedings, ang focus niya is properties. Okay, nakasentro doon sa properties ng debtor. Kasi nga, gusto na hilain ng creditors yung properties ng debtor. So, in the event case is filed in court, under the FRIA, okay, the proceedings is actually about the property, not necessarily on the persons involved. Because the court has to preserve the property for purposes of maybe rehabilitation or for distribution later on of the proceeds. Okay, so that is why it's called an in rem. It's not in personam, it's in rem. Okay, the focus is on the property. And jurisdiction of the court over the persons affected by the proceeding is considered acquired upon the publication of the notice of commencement of the proceedings in any newspaper of general circulation in the Philippines. So whenever may file na case sa court for insolvency, kailangan i-publish sa newspaper of general circulation so that all other creditors who were not informed of such proceedings will also be informed. Even if they do not read the newspaper, they will be considered as having been duly notified and informed. Okay. And then the court, after the publication, can proceed with the proceedings. And the proceedings is conducted in a summary and non-adversarial matter. So dahil peaceful negotiation ang purposes ng FRIA. The proceedings is not that strict like any other proceedings sa court, no? It's summary, ibig sabihin mabilisan, and non-adversarial. Non-adversarial meaning it's not about you and me quarreling over the properties. Okay? Because the court will have control kung anong gagawin sa properties. And by the way, class FRIA is also considered a procedural law. It's not a substantive law. Procedural in the sense that if you read FRIA, the totality of FRIA, it's about the processes involved within the court or outside the court, mga procedures sa procedural law. Okay. Hindi siya substantive law. Substantive law class, ang sinasabi sa substantive law kasi, what are the rights, what are the obligations, okay. Example of that is the civil code. Okay. Yung debtor-creditor dito under sa FRIA, yung creditor and debtor na rights nila is nasa civil code na kasulat, while the procedure on how to go about their claims is under sa FRIA. Because FRIA is necessarily a procedural law. So, debtor. I-define natin ang debtor under FRIA. Okay, a debtor who has become insolvent. So, when you say debtor, is an insolvent debtor. Maybe, number one, sole proprietorship duly registered with the DTI. So, I believe you already know what a sole proprietorship is. It's a business enterprise, okay, registered under the name of a natural person, okay. So, in that person, that sole proprietor may become insolvent later on, and he will be considered an insolvent debtor under FRIA. Or a partnership duly registered with the SEC. Take note, the law requires that this partnership to be considered an insolvent debtor under FRIA must be registered with the SEC. So you might ask, what about the partnership that has not been registered with the Securities and Exchange Commission? They may not be considered as a partnership for purposes of FRIA, but they can pursue insolvency proceedings individually. Okay? Not as a partnership. Pag hindi sila naka-register sa SEC. And then a corporation duly registered under the existing Philippine laws may also be considered as an insolvent debtor. So, ito, when I, okay, for later discussions, when I say juridical persons, I will be, the term will include partnership na registered with the SEC or a corporation duly registered with the SEC, okay, under Philippine laws or with the SEC. And then the last one is an individual debtor. Okay, so if you will look at this, the first three debtors are involved in enterprises, business enterprises. So they may become insolvent in the process. So they can be considered an insolvent debtor under FRIA. An individual debtor, itong pang-apat, is a person who has become financially distressed and he may not be involved in any business enterprise. Maybe he is an employee, okay, or a laborer, okay. So he can also become an insolvent debtor under FRIA, but he is not considered a sole proprietor. So an individual debtor, maybe an individual, simple individual debtor. The individual may also be a sole proprietor, and or the individual may be a partner in a partnership that has not been registered with the SEC. Okay, so pwede siya. Okay, the term creditor under FRIA is defined as a natural or juridical person which has a claim against the debtor that arose on or before the commencement date. Okay, so if you look at the previous definition of a debtor may be natural or juridical person. A creditor may also be a natural or juridical person. Tapos yung claim niya must have accrued before the commencement date. The commencement date later on you will encounter sa next discussions. This is the date that the court has declared to be the starting point of the proceedings. Okay, and the creditors have claims against the debtor. Okay, these are demands of whatever nature or character against the debtor or its property, whether for money or otherwise, liquidated, determined in account, or unliquidated, di pa lamang amount, fixed or contingent, matured or unmatured, disputed and undisputed. So if you look at this definition, it actually includes everything that the creditor has against the debtor. So lahat ng claims ipunin. So what is insolvency? Okay, when I say insolvency, of course, I'm referring to the debtor, not to the creditor. Okay, insolvency is defined by FRIA as a financial condition of a debtor, number one, where he is unable to pay his liabilities as they fall due in the ordinary course of business. So insolvent ang debtor if pag nag-due yung liabilities niya, hindi niya mabayaran. That is one form of insolvency. Or, dalawa kasi types of insolvency, where he has liabilities that are greater than his assets. Okay. Number two is, he has more assets than liabilities. Ibig sabihin, negative na yung capital niya. Okay. Number one kasi class, pwede siya mayroong maraming assets, kaya lang hindi siya in the form of cash. So that when his liabilities fall due, he cannot pay because he has no cash but he has many properties. Yun yung number one na scenario. Number two is, his assets is not really enough to cover his liabilities. That is another form of insolvency. Please take note of these two, maybe because they may ask this in the board exam. And also, you will use this discussion later on during the liquidation proceedings sa court. Okay. Kasi yung number one class, pwede pa i-rehabilitate. Ibig sabihin, pwede pa siya makabawi. Pwede pa siya kung, if this is a dying person, pwede pa siya i-resuscitate, i-CPR, i-mouth-to-mouth resuscitation, pwede pa siya gamutin. But the number two, hindi na kaya. You already can number two, you can proceed to sell all assets para yung proceeds pamigay na dun sa creditors. Yun yung number two. Okay. Number one may be a subject of, take note, rehabilitation. And number two may be a subject of liquidation. That is why ang title ng FRIA is Rehabilitation and Insolvency or the liquidation na later. Okay. So what is called the debtor's estate in insolvency? Ito lahat yung properties niya na naiwan. Yung creditor's claims, lahat ng claim ng creditor against the debtor. Ito namang debtor's estate, lahat ng properties ng insolvent debtor. Okay, so if you read the definition, so lahat ng properties na nasa kamay ng debtor. But take note of the exception, naka-underline. Lahat ng properties or assets held by the debtor pero hindi sa kanya because it is owned by third persons. Nasa kanya lang maybe because it was entrusted or maybe it was pledged or some other contract nasa kanya. Siguro gideposit sa kanya. Lahat ng properties ng third persons na nasa possession ng debtor is not included in the term debtor's estate. So that if the court would like to take hold of all the properties of the debtor, dapat hindi niya isama those properties na owned by third person even if it is under the possession of the debtor. In contrast, lahat ng properties and assets of the debtor na nasa kamay ng third person will be considered as part of the debtor's estate. Why? Because sa kanya naman talaga yon, nasa pinahawak man sa ibang tao. Okay. So when you say debtor's estate, lahat ng properties ng debtor. Rehabilitation. Ito yun. The individual, whether juridical or natural person, okay, may undergo rehabilitation. Ito yung naghihingalo pa lang pwede pa i-revive. Okay. So rehabilitation is defined by FRIA as the restoration of the debtor to a condition of successful operation insolvency. If it is shown that its continuance of operation is economically feasible, and its creditors can recover more by way of the present value of payments projected in the plan, if the debtor continues as a going concern, than if it is immediately liquidated. So, rehabilitation class, if may financial distress lang yung enterprise or individual, and then it is economically feasible na pwede pa siya i-revive, i-restore ito a condition of successful operation insolvency, i-rehabilitate talaga yan. Why? Because it is more favorable na i-rehabilitate siya, it is more favorable to the, not only to the creditor, but also to the debtor. Para everybody happy. Okay? That is rehabilitation. Take note lang sa rehabilitation is very important ang definition. I am not asking you to memorize this, but take note of the idea that under rehabilitation, the financially distressed person, whether juridical or natural, may still be restored if economically feasible. The court will do that because that is more favorable to both parties. Okay, so these are the kinds of rehabilitation under FRIA. This rehabilitation, kinds of rehabilitation, refers to the processes, the types of processes that may be availed of by the parties in order to rehabilitate the financially distressed person. Number one, it may be a court-supervised rehabilitation. Ibig sabihin, this is a type of rehabilitation that you have to file with the court. The first one is the voluntary proceedings. Voluntary because it is the debtor who voluntarily presented himself to the court so that he can be rehabilitated. By how? By filing a petition for rehabilitation. Okay, so kailangan niya abogado, mag-file sila ng kaso sa court. Okay, yung kaso nila is petition for rehabilitation. It is initiated by the debtor, that is why it's voluntary. The second one, court-supervised rehabilitation pa rin, but it will be called an involuntary proceedings because it is filed by the creditors against the debtor. Ano i-file ng creditor? Petition for rehabilitation pa rin sa court. You will also be needing a lawyer for this. Okay, file sila ng kaso sa court. Petition for rehabilitation ng debtor by the creditors. So, ito yung dalawang pwede i-file sa court. It may be voluntary by the debtor, involuntary if made by the creditor. Number two is pre-negotiated rehabilitation. An insolvent debtor by itself or jointly with any of his creditors may file a verified petition with the court for the approval of a pre-negotiated rehabilitation plan. Okay? So, sa number 2 class, nag-agree muna yung debtor at sa creditor about a rehabilitation plan, how to go about the plan, how to go about the rehabilitation. Then yung plan nila, ipa-approve nila sa court by filing a petition. Okay? The difference here, class, is sa number 1, wala pang approved na rehabilitation plan. Okay? Sa number 2, meron ng plan ang debtor and the creditor. Both parties have agreed to a plan. Agreed na talaga yun. Wala nang problema doon sa rehabilitation plan. Nag-agree na sila. Ipa-approve na lang sa court. Yun ang number 2. Okay? Sa number 1 kasi, yung rehabilitation is pag-uusapan pa. Okay? I-approve pa ng court. Pag-uusapan pa ng debtor at sa creditor. Well, ang number 2, na-come up na nila. Number 3 is out of court or informal restructuring agreements or rehabilitation plans. It is agreed by the debtor and approved by the creditor outside of any court proceedings. So, number 3, sila na lang nag-agree among themselves. Okay. Pwede rin, under sa FRIA. Okay. This is feasible if the parties involved are only a few and they are only talking about a few claims, few properties that they don't need to spend resources and time sa court proceedings. So, pwede yan, number 3. The FRIA allows that. Okay. So, these are the 3 kinds of rehabilitation class with 2 sub-kinds sa number 1. Please take note of this because we will discuss these procedures one by one. Okay, so 1, 2, 3. And we're talking about rehabilitation here class. Pwede pa i-revive yung business enterprise. Okay. And take note sa rehabilitation class. We're talking about business enterprises here. Pwede pa i-revive. An individual who is not engaged in business enterprise and who is insolvent may not be able to avail of rehabilitation because there is no enterprise to be rehabilitated. That is a logical conclusion there. So for purposes of rehabilitation, we are referring to business enterprises, which may be a single proprietorship, a partnership, or a corporation. Next one, liquidation. Dami ng terms. Take note class Yung insolvency refers to the 2 aspect of insolvency. Number 1 is the debtor is not able to cope up with the payment of obligation as they fall due. Yung second aspect niya is there are more liabilities than assets. Insolvency or insolvency ng debtor. Rehabilitation refers to the attempt to revive the business enterprise. Liquidation naman class refers to converting those assets into cash so that the proceeds can be distributed to the creditors in payment of all the obligations. Okay, hindi siya kasi this term liquidation was not really defined under FRIA. Ang sabi lang sa FRIA, liquidation refers to the proceedings under chapter 5. Yun lang sabi niya. But we know the technical definition of liquidation is about converting an asset to cash. Because cash class, while it is scientifically solid, it may be considered commercially liquid. Ang cash kasi class sa accounting and sa commercial laws are considered as some form of a liquid. Why? Because cash nagpo-flow, kaya may cash flow. Cash flows is the bloodline of the business world. Okay? Umiikot yung pera, umiikot ang capital, nag-flow. And as Conrado Valix would put it, ang cash daw is parang tubig because pag nilagay mo sa kamay mo, parang siyang tubig na madali lang mawala. Kahit anong close mo ng fist mo, maglabas pa rin yung tubig. Parang ganun daw ang pera. Madali lang siya hawakan, pero madali din siya mawala. So it's liquid. So liquidation actually is the process of converting those assets into cash. So this cash can be distributed to the creditors to cover their claims. Okay, may procedure din yan sa FRIA. Okay. And as a general view, liquidation will happen if hindi na ma-revive yung business enterprise. As a matter of fact, yung types of rehabilitation, yung kanina 1, 2, and 3, if during the procedures it is found out that it is impossible to rehabilitate anymore, the proceedings will be converted into liquidation na. Hindi na siya rehabilitation. Pwede siya i-convert. Especially those na nasa court proceedings. Okay. If upon the findings of the court that rehabilitation is not anymore feasible, then the proceedings may be converted into a liquidation proceedings and not anymore a rehabilitation proceedings. It's a liquidation. Wala siyang definition under FRIA. May kinds of liquidation din, class. Okay. Liquidation is resorted into if rehabilitation is not anymore feasible. Number 1, liquidation of insolvent juridical debtors. So, juridical debtors ito. I'm referring to partnerships and corporations registered with the SEC. Okay, there are 2 kinds, voluntary because it is filed by the debtor. And then number 2 is the liquidation, voluntary liquidation filed by the creditor. Okay, these are filed with the court, class. So, the number 1 type of liquidation is a court proceeding against a juridical debtor. Okay, maybe voluntary or involuntary. Doon kanina sa type of rehabilitation, yung voluntary and involuntary, pwede yun sa juridical and natural debtors, na persons na debtors. While dito sa liquidation, gano'n siya, iba ang juridical debtors sa individual debtors. Number 2 is about insolvency of individual debtors. Okay, so number 1 covers partnership and corporation. Number 2, insolvency of individual debtors. In letter A is a petition to be declared in the state of suspension of payments, or sometimes gina-shortcut nila into suspension of payments. Okay, this is also filed in court by an individual debtor who possesses sufficient property to cover all his debts, but foreseeing the possibility of meeting them, they respectfully fall due. Sabi mo, sir, pwede na siya i-rehabilitate? Kasi he has sufficient assets naman to cover his liabilities. Take note, class, we are talking about individual debtors. Okay, wala siya business enterprise. He may be a person, wala siyang business enterprise, but he has liabilities. However, he has several property pero hindi siya cash. So, punta siya sa court, asking the court na, court, i-hold muna ang payments, suspended ang payments. Dahan-dahan muna natin ibenta itong properties kasi marami naman. Saka natin ibayad. Kaya suspension of payments ang tawag. Okay? This is a form of liquidation ng individual debtor. Letter B, may voluntary and involuntary din ng individual debtors. Okay, sa letter B, class, he filed petition for liquidation filed by an individual whose properties are not sufficient. Take note, class, the difference. Letter A, suspension of payments, sufficient ang property to cover the debts, pero hindi mabayaran ang debts as they fall due because of insufficiency of cash. Maybe hindi cash ang kanyang properties. Maybe it's a form of property, plant, or equipment. Okay. Sa letter B is a liquidation filed by an individual who has less assets and more liabilities. Letter C, involuntary liquidation, of course, filed by the creditors against the debtor for liquidation. So if you look at the 2 kinds of liquidation with their sub-classifications, all of these class are filed with the courts. Okay, if you look at voluntary liquidation sa number 1, petition for liquidation, and then sa letter B, petition for liquidation din. Sa number 2 is a petition for suspension of payments. Okay, petition for liquidation pa rin ang voluntary and involuntary petition for liquidation. These are all filed with the courts. Okay. Baka kasi mag-away sila sa pera, class, kaya FRIA made it a point to have these processes under court supervision and control. Okay, so you might ask, sir, hindi ba sila pwede mag-usap na lang outside of court? Pwede naman. If nag-agree naman sila, naibenta yung properties, nabenta na nga, tapos binayad sa creditor, then the creditor went home happy, and the debtor also went home happy kasi nabayaran yung utang niya, then why not? It's not illegal. There is no express prohibition Okay, this liquidation proceedings lang under FRIA is designed, okay, to prevent quarrel among the debtor and creditors. If you have listened in the first slide about the objective of FRIA. Okay, so these procedures, especially now that it will be involving money, FRIA made it a point to have these proceedings under court supervision and control, okay, to temper the parties from quarreling with one another. So that is the end of this part 1. Okay, I made it very simple lang muna because there are so much technicalities when it comes to procedural laws. Just like in FRIA, daming technicalities. So simplify lang yung part 1. But in part 2, we'll be discussing the technical procedures for each proceedings under the court. Okay. But for purposes of this part 1, I want you to focus on the idea of why FRIA was enacted into law, to make the relationship between the debtor and the creditor harmonious in settling their claims. Number 2, rehabilitation. Insolvency, number 2 is the concept of insolvency. When is a person considered insolvent? Okay, number 1 is marami siyang asset pero wala siya masyadong cash, and as his liabilities fall due, di niya mabayaran, or he has less assets and more liabilities. And then also, I want you to focus on the concept of rehabilitation. In cases wherein it is still feasible to revive the business enterprise, then you resort to rehabilitation because it is more favorable to both parties. And the last concept that I would like you to retain in your mind is the concept of liquidation, wherein rehabilitation is not anymore feasible. Assets will be converted into cash, maybe through public auction, so that the proceeds can be distributed to the claimants. So you might ask, in closing, baka may question sa mind mo, sir, you said there is a case wherein there are less assets and there are more liabilities, kasi liquidate natin. Ibig sabihin, yung cash na ma-generate sa conversion ng assets into cash is also lesser than the liability. Yes, that is correct. And the court will distribute the cash according to the preference of credit. Sino yung mas preferred? Number 1, of course, yung mga secured claims. Okay, last na yung mga unsecured claims. Ang pinakaunang niyan is the government. Bayaran mo na yung buwis because the claim of the government is superior to our other claims. Sir, paano kung kulang na? Wala na mag-go ang korte, kailangan tapalan ni judge. Magtapal pa siya sa kulang. So, there is a procedure there na ma-distribute yung cash in accordance with law. Because according to the law, if ang claim mo 100, nabigyan ka ng 25 pesos, mas mabuti na lang yun kaysa 0. Okay? So, in the process of liquidation, it is not expected that the total amount for each and every claim will be totally covered by the available cash. Pero that is part of liquidation, and that is the best that can be done under that situation. Mas mabuti na meron konti kaysa wala. Okay? Sabi mo, sir, paano kung may utang pa rin na naiwan? Or in liquidation processes, liquidation proceedings, okay, the court will declare na tapos na yung pagkakautang. Okay. Sabi nga ng Supreme Court sa isang case, kapag ka na-declare na terminated ang proceedings kasi tapos ng liquidation, the person, yung insolvent debtor, is like a newborn baby, free from the sins of the world. Okay, so after that, hindi na siya pwedeng singilin pa ng mga kulang. Sabi mo, unfair ba? Unfair yata sir. No, it's not unfair because it's impossible for the debtor to pay the full amount because he has no more left. Okay. So, buti pang meron kang natanggap na konti kaysa wala. Yun ang concept doon. Okay, so see you in part 2.